There's been a lot of talk about Iowa's judges. This fall, some of Iowa's judges will be on the election ballot for retention. This video is meant to provide you with information about Iowa's judicial system and the retention election process.
You might have heard people talk about judges needing to be accountable to the people. You may also have heard the term activist judges, or judges are making law from the bench.
The truth is, judges are accountable to the people. Under Iowa's merit selection system, all judges must stand for a retention election 1 full year after they're first appointed. They then stand for retention every 6 years after that, except for the justices of the Supreme Court, who are voted on every 8 years. In other words, voters in Iowa get to decide whether a judge stays in office every 6 or 8 years.
But that isn't the real beauty of the merit selection system we use to choose our judges. The real beauty is that our system makes sure that judges stay fair and impartial by keeping politics and campaign fundraising out of the judge selection system.
Imagine that we elected our judges the same way we elect our governor, state legislators, or most everyone else in public office. We'd have judges raising campaign monies, giving speeches about why they are or would be good judges, and running negative ads about their opponents on television, radio, and in the newspapers.
In West Virginia, state court judges are elected. A few years ago, a big company lost a $50 million case at trial and knew the case would eventually be heard by the state Supreme Court. The company decided it would be better off if the Supreme Court had different justices. They spent millions on advertising that attacked a sitting state Supreme Court justice, and that helped lead to the election of a challenger. When the company's case came before the Supreme Court a few months later, that challenger was on the bench. Not surprisingly, the new court found in favor of the company.
Imagine that you have a small business and can't afford to contribute to a judge's campaign, and you are in a dispute with a large corporation that has contributed large amounts to that judge's re-election effort. How do you think the judge is going to rule? Probably not in your favor.
What if you're involved in a child custody dispute and you discover the other side's attorney contributed to the judge's campaign and your attorney did not? Are you going to feel good about your chances for a fair trial?
If we allow our judges to be elected, those who contribute lots of money to a judge's election campaign will have a distinct advantage getting a judge to rule in their favor. Put another way, justice would go to the highest bidder, or in this case, the highest donor.
In Iowa, our judges are selected based not on how much money they can raise, but through a process that reviews their qualifications, their experience, and their temperament.
In 1962, Iowa became the 4th state in the nation to establish a merit selection plan for choosing judges. Today, there are about 20 states that use a merit selection system.
Iowa's judges go through a rigorous process to be selected. A nominating committee, made up of an equal number of lay people appointed by the governor, and lawyers selected by Iowa bar members, interview the candidates, check their backgrounds, and verify their qualifications. The committee then chooses 2 or 3 candidates and forwards those names to the governor, who has 30 days in which to select one. As mentioned before, judges stand for retention 1 year after they're appointed and again every 6 or 8 years thereafter.
Proof that Iowa's system of selecting judges works effectively can be seen from the high rankings that Iowa courts receive every year from the U.S. Chamber of Commerce. The Chamber surveys every state's court system annually for its business members. Iowa ranked 5th overall in this year's survey and 4th for its fairness and its impartiality. A court system that is viewed as fair and impartial is attractive to businesses that are looking to locate in another state or want to expand their operations. An attractive environment for business means jobs and puts our state in a good position to keep our citizens working.
Judges sometimes are required to decide cases that are highly controversial. The Varnum decision on same-sex marriage is one example. Feelings in these types of cases run strong on both sides, and a number of people are certain to be disappointed with the decision. But judges rule on hundreds of cases every year. If you look at all of their rulings, you'll probably agree that justice was served.
Judges' rulings need to be based on our Iowa and U.S. constitutions and our state laws. Their rulings should not be based on politics or special interest groups or on who gives them the most money.
Obviously, judges are human. They have personal beliefs and biases. However, those beliefs and biases have to be kept to themselves when they are ruling on a case. Allowing their personal beliefs into a case jeopardizes their accountability to our state's laws and to the Constitution.
A fair question is, how are you to know if a judge is qualified to continue serving as a judge? How do you know if he or she is being accountable to this state's laws and the state and U.S. constitutions? Where is the proof that he or she is ruling without allowing personal beliefs or biases to affect the ruling?
To help voters answer those questions, the Iowa Bar Association conducts a survey of its members a month or so before the general election. ISBA member attorneys are asked to answer 12 questions related to each judge. The questions center on the judge's professional competence, knowledge of the law, punctuality, behavior toward the defendants and others in the courtroom, and timeliness in issuing rulings.
Iowa courts have a long history of considering controversial cases. The very first case reported in the territory of Iowa involved a runaway slave. This case was 25 years before the Civil War. Slavery was the norm in much of the country, and slaves were thought of not as people, but property. The Iowa Territorial Court refused to treat a human being as property and held that our Iowa laws extend equal protection for all people.
Another case involved the right of a black student to attend a school with white students. That 1868 case, Clark versus the Board of Directors, preceded the U.S. Supreme Court's decision on the same subject in Brown versus Board of Education by 86 years. At the time, there was an outcry at the judges' actions, but history has proven those judges were right, even if people then thought otherwise.
In Iowa, we know that when judges make decisions, they're not making them based on campaign donations or special interest lobbying. They're making them because they believe that's what the law requires. Iowa judges are accountable to the public, but when you cast your ballot in judicial retention elections, look past the hype around individual cases. Explore the ISBA survey and find out what the people who work with judges have to say about the work they do. You can access the survey at www.iowabar.org. Check it out and be an informed judicial voter this fall.
And when you vote, make sure you turn your ballot over to cast your vote in Iowa's judicial retention election.